We'll hear argument next in Case 21-1599, Polselli versus the Internal Revenue Service. Mr. Dvoretsky.
Mr. Chief Justice, and may it please the Court. Congress enacted Section 7609 to give the public critical privacy rights to notice and an opportunity to quash third-party IRS summonses. Congress carefully limited the exceptions to those rights. In Clause 1, Congress allowed the IRS to forego notice for a summons issued, quote, in aid of the collection of an assessment against the person with respect to whose liability the summons is issued. In Clause 2, Congress separately dispensed with notice for summonses, quote, issued in aid of the collection of the liability of any transferee or fiduciary of a delinquent taxpayer with an assessment or judgment. But the Sixth Circuit, like the IRS, nullified most of what Congress wrote. It read Clause 1 to contain just 9 words. A summons, quote, issued in aid of the collection of an assessment, period. The IRS says those 9 words mean that any time it's made an assessment, there are no judicially reviewable limits on its power to issue secret, overbroad, third-party summonses. So nothing stops the IRS from secretly summonsing all unredacted bank records of anyone who ever received money from a delinquent taxpayer, a lawn care company, a friend splitting a dinner check through Venmo, or, as here, a law firm. Never mind Clause 2, never mind the rest of the words in Clause 1, never mind the different language Congress used in another exception for summonses issued in connection with a criminal investigation. The Sixth Circuit and IRS's interpretation is inconsistent with the statute's text, context, and purpose, and it would create the same opportunity for abuse that Congress sought to eradicate. The question isn't whether the IRS can summons the records it needs, only whether it can do so secretly and without judicial oversight. The IRS says, trust us, we police ourselves. But Congress repudiated that approach when it enacted Section 7609's privacy protections for innocent third parties. I welcome the Court's questions.
You said that the IRS is not reading the entirety of the clauses. Would you tell us exactly what you're relying
on? We are relying on the broad notice rights in Section 7609 A and B, and then for purposes of the exception in Clause 1, we are relying on the fact that that it has to be in aid of the collection of an assessment made with respect to a particular taxpayer. So the aid of the collection language has to be understood to require a direct connection between the summons and the act of collecting, which means getting the money into the federal fisc. Aid of collection has to be understood to mean a direct connection in light of a few considerations. One is the ordinary usage of that term. 2 is the contrast between the language that Congress used there in aid of and the language that Congress used in C2E in connection with, which is broader, and relates to an F1, which this Court also has said has a broadening effect. This Court has interpreted similar language, such as in the electric power supply case, where it interpreted affecting to mean directly affecting in order to put reasonable limits on seemingly broad terms. And lastly, we're relying on the fact that under our interpretation, there is separate meaning to Clause 1 and Clause 2, whereas the government's interpretation creates massive surplusage by rendering all of Clause 2 and much of Clause 1 meaningless within this statute. Congress was simply wasting its time in writing those provisions, which is what Judge Kethledge recognized in dissent below.
The problem is the limiting language that you're asking about isn't there. It says the issued in aid of the collection of an assessment made or judgment rendered against the person. So where's the rest of your limiting language?
Well, I think the question is what in aid of means, and I think the limiting language is inherent in aid of. Let me try an example. In aid of isn't really an expression that I think people use in common speech, but let's try it anyway. You might say that I wrote this introduction in aid of presenting this argument today. You wouldn't say that I went to law school in aid of presenting this argument today. You wouldn't say that not only because I went to Yale Law School, but you also wouldn't say that because whatever I learned about advocacy in law school however many years ago, while perhaps helpful to me here today in some sense, just doesn't have a close enough relationship to what I'm doing here today to say that that is in aid of my presentation of this argument. So the very concept of in aid of in common parlance, to the extent it's used in common parlance, has a limiting principle. And that takes me, again, back to the electric power supply case. And in that case, this court interpreted the language affecting in the Federal Power Act, what affects a wholesale power rate. And the court said, look, lots of things could affect wholesale power rates. The labor market could affect wholesale power rates. That doesn't mean that FERC has the authority to regulate the labor market. The court interpreted the language affecting to mean directly affecting. And in aid of here in this statute has to have that same sense.